to talk about one of the more common criminal offenses, driving while intoxicated. Now, it's extremely important that if you get arrested for a DWI, that you contact an attorney immediately. And this is not for just fighting the pending criminal charge, but also to fight to keep your driving privileges. Because many people don't know that if you are arrested for a DWI, your license will be immediately taken. Again, you'll be given a temporary driving permit that is good for 40 days. Now, why you need to contact an attorney almost immediately is because you have 15 days from the date of your arrest to contest the suspension of your driving privileges. And if you get an attorney, we can file to have what's called an ALR hearing, which is where we cross-examine the arresting officer to see if he had probable cause to stop you and to take your license in the first place. Now, even though your temporary driver's license, the one that's given to you after your real driver's license is taken, is only good for 40 days, once you filed a request to contest that suspension, even if the ALR hearing isn't within that 40-day period, your license will still be good until that ALR hearing is held. Now, depending on the outcome of that ALR hearing, your license may be returned to you. So it's very, very important to get in contact with an attorney immediately after a DWI arrest so you can retain your driving privileges and all the privileges that go along with that. A lot of people are unaware that a DWI can be proven in 3 different ways. First way is the prosecutor has to prove that your blood alcohol content at the time you were driving the vehicle is above 0.08. Second way is the prosecutor can prove that you have lost your mental faculties. And the third way is a prosecutor can prove that you've lost your physical faculties. Now, the prosecutor, for proving a DWI, does not have to prove all 3. The most common one, obviously, people are used to is the blood alcohol content being above 0.08, because it's the easiest to prove either with a blood test or with a reading on the breathalyzer machine. But that doesn't mean that if your BAC is below 0.08 that you still can't be arrested and charged for a DWI. It just now becomes more a matter of opinion and whether or not the arresting officer thinks that you have lost either your physical faculties or your mental faculties, what the prosecutor can then take up and attempt to prove in court. Now, if you are arrested for a DWI for the first time, it is simply a misdemeanor offense, so you will be in misdemeanor court facing misdemeanor punishment ranges. And a common punishment for a first DWI is simply a 1-year probation, community service, possibly a fine. But the good thing now in Harris County is the prosecutor's office has started what's called pretrial intervention, which is essentially a first chance program for first-time DWI offenders. And this is a great program for people that fit the parameters of getting into the program, because if you complete the terms of your probation, and it's a year-long probation with various other factors, community service fines and whatnot, that the DWI will eventually be dismissed from your record, which is a very good thing. If you are arrested for your second DWI, you are ineligible for this first chance program because it's not the first DWI anymore. A second DWI is still a misdemeanor, you're still in misdemeanor court, it's just the punishment range will be a little bit higher. So as opposed to having a 1-year probation, you may have an 18-month probation. Now, if you are arrested for your third DWI, then that's going to kick you up to felony court, and you're going to have to fight to keep a felony conviction off of your record. Also, that if you're caught driving and arrested for being impaired behind the wheel and you have children in the car, a child less than 15 years of age, that also is a felony, and that also will be a bigger fight since you are now in felony court. You can also be charged with a DUI, or driving under the influence of an illegal substance. And this happens if you consume drugs that impair your mental or physical abilities while operating a motor vehicle. The same process goes for getting a DUI. The prosecutor still has to prove that you were impaired at the time of driving. It just might be a little more difficult because there's no set amount of any type of drug that the prosecutor needs to show that was in your system. It's essentially just showing that you were impaired, your physical faculties and your mental faculties were impaired at the time you were operating that vehicle. And again, that simply is a matter of opinion. It is the police officer's opinion, his reason for pulling you over, and then the prosecutor's opinion trying to convey that message to the court that you were indeed impaired because of an illegal substance.